Yachts and boats, commercial marine, high-performance boats. Yep, we've gone boating. Arrowhead Marine Insurance, available coast to coast.
Director and officers' liability coverage is increasingly being called up to respond to cases involving the Foreign Corrupt Practices Act. But is this right? Susanne Murray, Executive Vice President for Alliant Insurance Services, discusses this expansion of D&O coverage in this interview with Insurance Journal's Andy Simpson at the recent Professional Liability Underwriting Society's D&O conference.
The evolution of fines and penalties coverage really does start with what's covered by the policy, and that's found in the definition of loss. Loss generally covers damages, judgments, settlements, and defense costs. And then policies typically go into the but loss does not cover. And it used to say loss does not include punitive, exemplary, multiplied damages, fines, penalties, or taxes, or matters uninsurable under the law. And different policies have other things they also don't include in the definition of loss. But those are kind of the standard ones. So the evolution of that has been suddenly we get coverage for punitive, exemplary, and multiplied damages. People said the same thing, which is it's supposed to be punitive in nature, punishing in nature. Why would we let an insurance carrier pay those costs when you're supposed to be punished? And hardly, you don't feel it if your insurance carrier is paying it, right? Nonetheless, eventually, the insurance policies began to pick that up. Now, to be honest, they picked it up because, generally speaking, the primary claims against directors and officers of public companies are securities claims, and under the federal securities laws, you don't generally have the ability to have punitive damages awarded, although you do under state laws and under non-U.S. laws, certainly. Nonetheless, that was the evolution. First, punitive, exemplary, and multiplied damages. And then now the next step is certain types of fines and penalties can be insured. That began with the idea of it's a fine or a penalty that can be imposed that isn't necessarily because you did something wrong. It could be an unintentional violation of a statute, as an example. So that's where kind of the first baby step, toe in the water, were kind of minimal fines and penalties. One of which is the Foreign Corrupt Practices Act. That act sets forth 3 different stages of wrongdoing, different levels of impropriety or intent or wrongdoing. The most insignificant level, you were negligent, you inadvertently bribed somebody, or you inadvertently did something that would be perceived as inappropriate, covered. So what we've had is a change in many of these policies to say loss includes Foreign Corrupt Practices Act fines and penalties under this particular statutory section. What most people don't understand is that particular section is only to the most insignificant of the penalties that can be awarded. So this is actually an issue because many insureds would report to their boards, I have coverage for Foreign Corrupt Practices Act fines and penalties, and they do, but only to a degree. So there are certain carriers who are willing to just say Foreign Corrupt Practices Act fines and penalties without a reference to a citation, and therefore without limiting it to only that which is found in that particular statutory provision. There are other carriers, though, who have gone far beyond Foreign Corrupt Practices Act fines and penalties to other fines and penalties, and even to any other fines and penalties. So some carriers have been willing to say loss includes fines and penalties if insurable by law.